Hello, everyone, and good evening. I hope everyone is doing wonderful. My name is Yael. I'm an immigration attorney coming to you live. I'm live on Facebook and on YouTube um, from our office here in Orange County, California. Orange County, those of you that don't know, Southern California, we are located between LA and San Diego. So I am here live. I am so happy to be here to answer your immigration questions. I try to go live every week, at least once a week, to be able to answer folks' questions about immigration. So if you are thinking of filing an immigration case or you have an immigration case pending and you have a question, I got your back. I'm here for you. Please feel free to write your questions in the comments and I will try to get to them as we go. And if you are watching a recording of this, then also you can still write your question, and as soon as I see it, I promise to answer it as well. Everything we talk about today is general information. So I won't be giving out specific legal advice, but I will be giving great information today about U.S. immigration. And we have had some wonderful questions come in this week. So I'm excited to share with you some of the questions I thought would be the most interesting for folks, really across the board. Okay. If you're new here on our channel, first time on Facebook, first time on YouTube, please feel free to like our page and subscribe to our channel. That way you can get more information about these kinds of live events and you can get all kinds of updates about immigration. Okay. Awesome. Well, if you've been following me for a while, you know probably that I have been encouraging everyone to start their immigration case. So if you have an immigration case, you're thinking of filing for yourself or petitioning a family member, I really want to encourage you to do it as soon as possible. And there's a couple reasons for this. First reason is that filing fees are going to go up. Okay? They're going to go up. They're expected to go up this year. And that means that everything is going to be more expensive. So if you're already thinking about filing a case, the best thing to do is to take advantage of the filing fees that are currently available and not wait until these fees go up. Okay. Second thing is that we are in an election year. Okay. It's hard to believe it, but this November we're going to have an election. An election year means that we might have a new administration next January. And new administration means changes, means that certain policies that are now available and open to people can be canceled, can be stopped. So if there is an immigration benefit that you are eligible for or qualified for, don't wait for these benefits to go away. Take advantage of this now that it's available for you. Also, we are in a very good, favorable administration right now. We've been seeing good decisions come out from immigration. We've been seeing quicker processing times. We've been seeing interview waivers for marriage-based green cards and for employment-based green cards. So really, it is a good time to file your case. I think it's been the best time to file in the last decade. So if you're sitting on the fence, I hope me right now, I'm able to persuade you a little bit to take that first step. Sometimes taking the first step in your immigration case is the hardest. A lot of people are sitting on it and just procrastinating and not making the decision to start because they're busy and they don't have time, or because it's an investment. It's a financial investment to take a lawyer to start your case, to pay filing fees, and maybe they don't have the budget for it. But with all of those factors in mind, I want to encourage you to file your case as soon as possible. Okay, start your case. Starting a case with immigration can be as easy as picking up the phone and scheduling a consultation with an attorney. Because when you do that, you get a great understanding about your situation, about processing times, about certain criteria and requirements that are now required. Okay, so take that step. You can do it. Okay, so you ready to jump into some questions? You have really great questions. And if you have a question, please feel free to write them in the comments. And I promise to try to get to them as we go. Okay. Perfect. Okay. So the first question that we have today is, what are the requirements of the fiancé visa and how long does it take? Okay. Fiancé visa is a really great option. It's available for U.S. citizens. So U.S. citizens can petition for their fiancés, foreign-born fiancés that live in a different country, to come to the U.S. for the purpose of getting married to them. Okay, so the process starts with the U.S. citizen putting in a petition, putting in a request. Okay, once that petition is approved, then the fiance that lives in a different country can go apply for the fiance visa. So you can't just start with applying for the fiance visa. You first have to have your US citizen petitioner start the process for you, file that petition for you. Okay. Now, what are the requirements for the fiance visa? How would you know if you qualify? Well, the requirements for the fiance visa are actually pretty low. They're not very extensive. What you would have to show is that you're a US citizen, right? You're starting this process. You are the petitioner, that you are both, you and your petitioner are legally allowed to get married, right? You're not already married to someone else, or still married to someone else. And that you've met at least one time in the last 2 years. Okay, there's a physical meeting requirement, but just one time in the last 2 years. And that you intend to get married in the United States within 90 days of foreign national entering to the US. So the requirements for the fiancé visa are not very hard. You don't have to show that you've been together for a long time or that you've met many times, right? So those are the requirements, okay, to get the petition approved. Now, how long does it take? Is probably the hardest question, the most frustrating question you can ask, because it really is hard to tell. It's inconsistent, it's unpredictable, but usually we're seeing fiancé visa between 12 and 18 months, and it depends on the embassy in the foreign national's country. So you would think about 12 to 18 months from the day you file your petition to the day that your fiance can come to the United States. Now, after your fiance comes to the United States, you have to get married within 90 days. That is one of the conditions of this visa. And after you get married within 90 days, then the foreign national can apply for the green card in the United States, which takes another 12 months, pretty much. Okay. So if you are interested in the fiance visa, if you have a US citizen, you're a US citizen or you're a resident and you have fiance or a spouse or a girlfriend in a different country and you want to help them out, you want to start the immigration process for them, then feel free to reach out to us. I actually wrote a couple's guide to immigration. So because so many of our clients are going through this process through marriage or through fiance, through a relationship, I came up with a couple's guide for immigration. So if you are interested to receive a copy of our free couple's guide to immigration, just let me know and we'll send you a link. Okay. If you're watching the replay of this, just write a comment to ask for a copy of the couple's guide. Awesome. A good question. Okay, let's jump into another question. Okay. Can you explain about the VAWA option? How do I qualify? Okay. So really good question. Very important. I'm super happy for whoever asked it. So thank you so much. VAWA stands for Violence Against Women's Act. Okay. It's an abbreviation of this whole law. And even though there's the word women in it, it doesn't mean that it's just for women. It applies for men exactly the same. Okay. Basically, it's a way for you to get your green card based on a relationship to a US citizen or a resident if you've suffered from that relationship from extreme cruelty or abuse. Okay, it's a self petition, and that means that you do not need the help of your partner or your US citizen relative that's this petition is based on. It's a completely confidential process. In fact, the your partner or your child that you are filing this case about will not even know that you're doing it. Okay, it's a very safe option. If you are in a relationship with a US citizen and it's an unhealthy relationship because you are suffering from emotional abuse, psychological abuse, of course, physical abuse as well, but that is not required at all. A police report is not required. Any kind of unhealthy dynamic between you and your spouse or between you and your US citizen child could mean that you're eligible for VAWA, for a group to which means that you would be eligible to petition for your green card by yourself, for yourself, without any help from your spouse or your partner or your family member. VAWA green card is also a very generous humanitarian green card, so it forgives a lot of things. It forgives entering the country without permission, so entering legally, working without authorization, overstaying in the United States. So it is a very generous option. So if you are interested in VAWA, if you think you might be eligible for this, please reach out to us, and we would love to help you and advise you about the process. Okay. Hi, Mr. Tusk. You're interested in the copy of the marriage guide, so I will definitely send it to you. Let me see if I can do it now. Let me see if I can get that for you. If not now during our live, I will send it to you after our live show. Okay. Okay. Can I petition my wife if I am unemployed? Okay, this is a really common question that we get a lot. It has to do with the requirement to file an affidavit of support, a financial support requirement for anyone that's petitioning their spouse or their family member. Okay, so if you are petitioning your wife, you do have to show that you meet a minimum income. And that minimum income is determined by how many people are in your family, how many people are in your household. Okay, so the more people that you have in your household, the higher the amount that you need to show of income. Okay, so for example, for a family of two, the amount that a petitioner would need to show is that the petitioner has income of at least $24,600. Okay. You can show income through through your work, or you can also show that you have assets that meet that threshold. So if you have any property, real estate property, or if you have any savings, or you have any stocks and things like that, those are other ways that you can show that you meet a specific financial threshold. Now, if you're unemployed, so you don't have any income coming in, and you also do not have any assets or something significant that you can show instead of the income, you can still petition your wife. However, you would need a joint sponsor. And this is very, very common. We do it on a daily basis with these kinds of petitions where we add a joint sponsor. And a joint sponsor could be a family member, a parent, a brother, an aunt, an uncle, a friend, a coworker. There does not need to be a familial relationship. The only thing you will need is for the co-sponsor to either be a lawful permanent resident or a citizen. And preferably, you're looking at someone that's employed. Okay, that's working for someone that has a steady income to be your joint sponsor. So definitely don't be discouraged if you're unemployed. You can still definitely petition for your spouse. You can start the process. However, you would need a joint sponsor. Okay, and these are the kind of examples that I talked a little bit before about people waiting to be employed to petition, right? Because they want, maybe they want their petition to be stronger and they want to show that they have income. Well, in this environment with immigration, I would not wait. If you have a joint sponsor, I would just go ahead and file the application because it doesn't really matter. And you want to take advantage of this administration and you want to take advantage of the filing fees before they go up. Okay. Okay, if you're joining us now, thank you so much for being here. I'm immigration attorney Yael Brudner. I'm answering immigration questions today. So if you have a question, feel free to write them in the comments. And if you are watching this as a replay at a later time, you can still write your comments. I'm happy to answer your questions as I see them. Perfect. Let's see. Okay. I was scheduled for an interview for my green card case. I heard a lot of people are getting interview waivers. Is this a bad sign? Okay. Well, congratulations on getting scheduled for a green card because that's most likely the last step of your case. It's kind of the final point where immigration is going to make a determination on your case. And it's true that many people are receiving interview waivers. However, that's not everyone. We are still going to green card interviews frequently, and we don't know all the internal reasons why USCIS is sending people to the route of interview waiver versus people going to interview. Okay, and generally speaking, the interview has always been traditionally there, right? Just now we are seeing an attempt to move cases along and reduce some backlogs by USCIS. So that's why they are waiving some of them. But if you are scheduled for an interview, it's not a big deal. It's not the end of the world. It doesn't necessarily mean that it's a bad sign. I would definitely recommend, though, to be prepared for your interview. So the best way you can prepare for your interview, in my opinion, is to meet with an immigration attorney and have a preparation session before your interview. If you're not represented by an attorney and you get an interview, you can always have an attorney come with you to the interview, even if that attorney didn't file your case to start with. Okay, and why is it important to have an attorney with you at your interview? Because an attorney can advocate for you on the spot. Okay, an attorney is the only one that can come with you to an interview. You can't bring a friend. You can't bring, your parents or your brother. You can only bring your attorney, right? An attorney can be there. An attorney can monitor that everything is going proper, that the officer is asking you questions they're supposed to ask, right? We know what they're supposed to be asking, and the officers know that we know, right? So having an attorney in the room just changes the entire dynamic in my opinion. It just makes the officer more careful with what they're asking. And an attorney in the room is also a witness to what's going on. An attorney can take notes because if later there's a request for evidence, then you would have documentation of what actually you said, what was asked and what you said and how you responded. So I could not recommend it enough to at minimum have a preparation session. So have a conversation with an attorney where you talk about what to expect at the interview. The attorney can review your application. You can practice answering trickier questions if you have anything in your case it's a little bit more tricky. Okay, and ideally, if you can have a prep session and interview representation by an attorney, that would be the best. Okay, perfect. Okay. I'm going to jump into the next question. I have about a couple more questions that I'm going to answer today, but if you are here and you want to ask me a question, so now is a good time to do it. Okay. My son is in the military. Can she help me get my papers? Okay. So if your son is in the military, U.S. citizen in the military, there is a great chance that he will be able to help you with your immigration status. Okay, so there is a special benefit for members of the military called parole in place. And parole in place is an option for people that have entered the United States illegally, unlawfully, one time, and they've been here ever since, and now they have an option to be petitioned, right, by their child. You know, the child just turned 21, and the 21-year-old child can petition them, and now they want to apply for their green card. Well, if you don't have anyone in the military in this situation, you would need a qualifying relative. You would have to go to back to your home country, and you would most likely need a qualifying relative to ask for a special waiver. And a qualifying relative is only a U.S. citizen or green card holder spouse or parent. So a lot of folks, when their son turns 21 or daughter turns 21, they're stuck because they don't necessarily have a way to get their green card. So being in the military might allow you to do the whole process here in the United States without having to leave through the process called parole in place. Okay. So if you think you might be eligible for this, I really, really encourage you to consult with an attorney, see if the attorney can help, if you qualify for it. It's a great way to fix your status in the United States, get your papers without leaving the US, and without needing any waivers of forgiveness and not needing any qualified relatives for that. Okay, perfect. Okay. So our information is here on the screen. If you want to reach out to us, we're happy to help. You can feel free to call us or text us at any time. Okay, perfect. Okay, let's do another question. I got a request for evidence for my birth certificate, but I already sent it the first time. Should I send it again? This happened to us this week, the same thing. You know, sometimes we joke that we don't know what's happening in the USCIS mailroom, but sometimes we feel like they take our packets and they just throw it in there, and they just catch it just for fun, and then they lose papers on the way. I'm just kidding. That's probably not what they're doing, but sometimes it feels like that. So sometimes it feels like, why are they asking me for something that we've already sent them? Did they lose it? What happened? So if you received a request for evidence for something that you've already submitted, I know it's really frustrating, but the best thing to do is just send it again together with the request for evidence. Send in that document that they're requesting. Now, with the birth certificate, you need to be really careful because sometimes they're not just asking for a duplicate birth certificate or the same thing again. Sometimes they're asking for a specific birth certificate. So some countries, after certain years, started to issue a long form birth certificate, which is different than what you had when you were born, what you received when you were born. And sometimes immigration, and they're definitely not consistent with this, but sometimes they insist on you getting that later version or the longer version of your birth certificate. So my recommendation is to read this request for evidence very carefully and to look into what they want. What is the birth certificate that you submitted, and what is the birth certificate that they're asking for? Okay, usually they will also refer you to the Department of Homeland Security website, where they would tell you for each country which is now the acceptable birth certificate. I know, sounds super complicated, but just read the instructions on the request for evidence, and it should really spell out what is needed there. Awesome. Well, I think we've answered all the questions for today. Thank you so much for everyone that joined today. It was a pleasure. And if you're watching the replay of this, feel free to ask questions, and I will try to get to them as I see them. If you're new here, please like our page, subscribe to our channel so that you can get more updates about everything immigration. So I will be here very soon. And until next time, have a wonderful rest of your week and wonderful weekend, and take care. Until next time.